Yeah, sure.
Yeah, I'm just like kind of interested in it. Yeah, no, please come grab a cupcake and sit down. Are you part of the organization? Yeah. Ooh, for fans. Thank you. No, like I have to watch a lot of there's also red velvet back there.
It's all about the same.
You want to like that or you want to?
Yeah, that's good.
Ready?
We should close the door here so people don't come in from the front. Yeah, sure. That's fine.
Feels like a class to me now.
Yeah, there you go.
Yeah, I'll know the camera when you guys get there.
Good evening. My name is Sam Zork, and I'm the president of the Rice University Federalist Society. On behalf of our officer board, consisting of Jed Greenberg, Anson Fung, Tanya Pignon, Sage Simmons, and Anthony Saliba, I'd like to thank you all for coming to our event. In our increasingly polarized society, it is becoming rare to find an environment where those who disagree on important questions can sit down in the same room and have a civil discussion. We believe that pluralism and tolerance towards others is important, and by joining us today, you are all contributing to that revival. As our second event of the semester, we are excited to be hosting this debate on the Masterpiece Cakeshop, the Colorado Civil Rights Commission case between Austin Nimocks and Mitchell Katine. Moderating our debate will be Dr. Paul Brace, the Clarence L. Carter Professor of Political Science here at Rice. Dr. Brace's work focuses on state and intergovernmental politics, judicial decision-making, and the presidency. His current research, funded by the National Science Foundation, investigates on strategic behavior in state Supreme Courts. Dr. Brace also serves on the Council of the Midwest Political Science Association. He holds a bachelor's degree from the University of Oregon and a master's and PhD from Michigan State University. Thank you, Dr. Brace.
Thank you, Sam. Good evening. In 2012, Dave Mullins and Charlie Craig walked into a Masterpiece Cakeshop in Lakewood, Colorado. They went there to purchase a cake for their wedding reception. They were not married in the state of Colorado because Colorado didn't honor gay marriage at the time. they married outside the state came back and sought to buy a cake. The bakery's owner refused to serve them solely because they're a same-sex couple, which was contrary to his religious beliefs. Colorado courts found that the bakery discriminated against Dave and Charlie, violating a state public accommodation law that says businesses open to the public can't turn away customers based on sexual orientation. Notably, 20 other states have such public accommodation laws. Now the bakery is asking for a constitutional exemption. They've appealed that case to the United States Supreme Court, and I believe it's going to be argued in December?
December 5th.
December 5th. Okay. They're asking for an exemption, which would be a permission to violate the state law based on the owner's objection to serving same-sex people. It's interesting that 2 years ago the justices turned down a similar appeal from a wedding photographer in New Mexico. Since then, the issue has arisen in several other states, and as I mentioned, there are 20 states with those public accommodations laws. So the issue for the court is whether applying Colorado's public accommodation law to compel the petitioner to create expression that violates his sincerely held religious beliefs about marriage violates the free speech or free exercise clauses of the First Amendment. In political science, we crudely gauge the importance of cases sometimes by the number of amici briefs that are filed. Amici are friends of the court briefs. The court is not bound by them at all. It is efforts by groups and individuals to try and influence the court by offering briefs, friend of the court briefs. And to stimulate the submission of those briefs, normally some fairly significant issues have to be in play. Some cases get very few amici. Notably, I counted today, this case has attracted 94 amici. That is amazing. So we have a very important case before us, and we are grateful to the Federalist Society, not only for providing cupcakes, but for also bringing two leading legal minds tonight to debate this important topic. Austin Nimocks is the Associate Deputy Attorney General of the state of Texas since 2015. He got his bachelor's in business administration from Baylor University and also his JD from Baylor University. Notably, he was senior counsel and director of legal advocacy for the Marriage and Family Division of the Alliance Defending Freedom. The Alliance Defending Freedom aided the cake shop owner in assembling his appeal to the United States Supreme Court. Mitchell Katine is the founding partner in Katine and Nechman law firm. He got his bachelor's degree from the University of South Florida and his JD from South Texas College of Law. He's been a member of the Texas Real Estate Commission and also an adjunct professor at South Texas College of Law since 2001. Our format for tonight is 15 minutes for initial comments, 10 minutes for rebuttal, and 5 minutes for further discussion after that, and then we'll open up to question and answer after that. And based on the order in which the names were submitted to me, Mr. Nimocks will go first.
Well, thank you for that introduction, Dr. Bray, Sam, and members of the Federalist Society here at Rice. Thank you for hosting this event. It is my pleasure to be here. And Mitchell, thank you for being willing to come participate with me. It's an honor to meet you, and I'm looking forward to it. First and foremost, I have to preface my remarks, as we often do when we step outside of the office and speak, and say that even though I am employed by Attorney General Ken Paxton, my remarks here tonight are my personal remarks and do not reflect those of General Paxton or those of the Office of the Attorney General of Texas. In the landmark case, that's a good way to start. In the landmark case of Obergefell against Hodges 2 years ago, when the Supreme Court found a fundamental right to same-sex marriage, the Supreme Court also said this, quote, "Many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises. and neither they nor their beliefs are disparaged here, unquote. Those are the words of Justice Kennedy, who wrote the opinion. In his dissent, Justice Alito stated this, quote, perhaps recognizing how its reasoning may be used, the majority attempts to reassure those who oppose same-sex marriage that their rights of conscience will be protected. We soon will see whether this proves to be true. I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes, but if they repeat those views in public, they will be risked for being labeled as bigots and treated as such by governments, employers, and schools, unquote. The question before the Supreme Court here is treatment by the government to a particular small business owner, Jack Phillips of Masterpiece Bakery. And so here we are. At stake in this case is whether those that do not support or believe in same-sex marriage or hold a traditional or alternative view of marriage and their decent and honorable beliefs, to use the words of the Supreme Court, may, consistent with the protections of the U.S. Constitution, be disparaged by state governments. Here, Colorado, in a law that imposes fines and prospective jail time to anyone who does not comply. But there's really so much more to this case than somebody's right to speak about same-sex marriage, because here the speaking is happening through artistic expression by this particular cake artist in Colorado. And there's no debate, the Supreme Court has confirmed multiple times that artistic expression, not just words from our mouths or thoughts in our brains, is protected speech under the First Amendment. Contextually, in the background, we have to remember that one of America's enduring contributions to the world and free society is our broad protection for free speech. We are unique in the world in this regard. And many of us will subscribe to belief in and agreement with principles of free speech and free exercise. But the question is, when we are encountered with it, when it truly offends us. We have to ask the question, it's easy to say, I believe in the First Amendment. I believe in your freedom of speech. It becomes really hard when we are encountered with free speech that actually stirs something inside us, that offends us, or that we don't, in fact, agree with. This is when your beliefs are really put to the test. The question is, do I believe what I say I believe if I espouse a belief or support for the First Amendment generally? Because if you really believe what you say you believe in terms of supporting the First Amendment and the right to free speech, then you must be willing to advocate for the right of somebody to speak freely in a way with which you disagree. And that is an important principle of the First Amendment. Many of us, unfortunately, only care about free speech when it's something that we care about. Conservatives, I've noticed, love to preach free speech when provocateurs like Ann Coulter, for example, are banished from public college campuses. And they're wrong to do so. And conservatives talk about free speech. But I question whether conservatives or those on the right side of the spectrum clamor as loudly when speech that they don't agree with is likewise unequally treated. Of course, those on the left side of the political spectrum are equally guilty in that regard. And today, unpopular speech, or speech that's unpopular with those on the left side of the political spectrum, is oftentimes characterized as hate speech. And by labeling it hate speech, it's designed to create some kind of exception to the First Amendment, as if speech that is done with impure motives, or is viewed to be hatred or vitriolic, is somehow treated with less constitutional protection than other speech that some may or may not agree with. Somebody's subjective feelings about the speech that they're hearing or receiving has never been the standard for whether it's protected under the First Amendment. So understanding and defending the First Amendment requires what many legal scholars acknowledge as an act of courage. Mark Twain said that courage is resistance to fear and mastery of fear, not the absence of fear. If you believe in free speech, are you willing to listen to and tolerate beliefs, viewpoints, and principles with which you may not agree? The Supreme Court has done this many times. There have been many cases before the United States Supreme Court where speech that is considered vile or just despicable or in the views of an overwhelming majority of Americans has no redeeming value whatsoever. I think about the case of Jerry Falwell against Hustler magazine. where Hustler magazine did a portrayal of Jerry Falwell in a very despicable, some people believe, manner, characterizing the Reverend Falwell as having had sex with his mother in an outhouse. And yet the Supreme Court said that is free speech. That is worthy of constitutional protection. There is a so-called church that exists in America today called the Westboro Baptist Church. And the Westboro Baptist Church routinely pickets military funerals. Funerals of fallen soldiers with signs that are absolutely, in my opinion, disgusting. They read things like, "Thank God for dead soldiers. God hates fags. God hates the United States. Thank God for 9/11. America is doomed," all to espouse their belief that America is doomed because of America's tolerance of homosexual behavior. The Supreme Court, by an 8-1 decision, with Justice Alito, ironically, being the only dissent, said that that is free speech that's protected. We may not agree with it, hardly anybody does except for the Westboro Baptist Church, and yet that is protected free speech. Of course, the speech we have before us in the Masterpiece Cake case is not even remotely close to the speech by Hustler magazine or the Westboro Baptist Church. This is speech that is regarded universally as absolutely beautiful. Jack Phillips, the cake artist at the center of this case, was specifically sought after and has been sought after because he makes beautiful art. He has been, his cakes have been noted on the TV show Cake Boss. People seek him out. He's won awards and won an award for the best wedding cake of the year, I think it was, on the popular wedding website, The Knot. This guy is a true artist, and he does wonderful work with his cakes. And this is why, before the Supreme Court, and you heard that Dr. Brace mentioned all of the amicus briefs that were filed by others before the Supreme Court. One amicus brief that I think is extremely notable was filed by nearly 500 expressive artists. And they filed it in support of neither party. But the point of their brief to the Supreme Court was to say, Supreme Court, what we do is art. And who is we? It included painters, muralists, authors, actors, writers, sculptors, paper crafters, calligraphers, graphic designers, cartoonists, bloggers, web designers, musicians, florists, photographers, journalists, videographers, ceramic artists, poets, and songwriters. And we could probably go on and on if we wanted to debate and list all of the creative and expressive artistic professions that exist in the world today. And the universal point of their brief was that what we do is artistic. This is art. This is expression. And it's protected under the First Amendment. They argue that the design and preparation of custom cakes is an artistic and expressive activity, that wedding cakes specifically are the most iconic examples of the cake artist's craft. Wedding cakes are readily identified at a glance, they argue, but their magic lies in the details. And expressive cakes can create deep meaning for many other occasions. And the cakes of enormous beauty exemplify the cake artist's character regardless of linkage to any specific person and event. There's really no question, at least in my mind, and I suppose this may be where part of our debate today goes, over whether the custom creation of a wedding cake is in fact artistic expression. And let's be really clear here about what the facts of this case are. Jack Phillips was asked to design and create a custom wedding cake. The gentleman who approached him had specific specifications in mind. They wanted a work of his art. And when he creates a wedding cake, he actually has the canvas with the base of the cake. There is artistry and design, and he actually paints the way that cake artists paint their specific cake with the design. There's really no debate, could there be, that if somebody walked into an artist, what we consider a traditional artist who has a canvas with a paintbrush, and said, I want you to paint X, and the artist didn't like or agree with X, so let's just take an example that will resonate today. I want you, artist, to paint a picture of Donald Trump, and the artist is an ardent Democrat, and does not like Donald Trump at all, despises him in fact. Would the law actually require this artist to paint the picture of Donald Trump? Of course it would, because the artist's expression, what they do, is protected by the First Amendment, and in like manner with regard to Jack Phillips. Jack Phillips made clear to these two men when they walked into his cake shop that he would sell them anything in his shop. Anything that he had made, they could buy. If they wanted brownies or cookies, which are literally done with a cookie cutter, and just kind of a product that was produced in mass, so to speak, like that, they could buy anything, and he would be happy to do that. But creating a custom-designed wedding cake is what goes to his core and his soul and what he likes and what he wants to believe, or what he does as an artist every day, and is why he opened the shop. This man, Jack Phillips, from a young age, enrolled in every art class he could, from poetry to watercolors. He is an artist at heart. After high school, he discovered that he could blend his love for sculpting, painting, and sketching with baking to work as a cake artist. He worked in various bakeries until he opened his own shop, Masterpiece Cakeshop, and he chose the name Masterpiece specifically for two reasons. Number one, to emphasize that he creates art. When we hear the word masterpiece, what do we think of? We think of the Mona Lisa. We think of artistic paintings hanging on the wall in hallowed museums. And that's why he did that, because he creates art through his custom cake designs. And to remind himself that making money is not his ultimate master, because he exists to serve God. And this goes to the question of his religious freedom as well. The logo for his cake shop is an artist's palette with paintbrushes, and it has been from the very beginning. And when Jack opened his shop, a local newspaper wrote a story calling Masterpiece Cakes a, quote, gallery of cakes. The article still hangs in his shop. This is a true artist who believes in what he does and has every right to be protected by the First Amendment from not having to dedicate his mind, his heart, and his conscience to something that he doesn't believe. Would this case be different if a rogue bakery that makes white sheet cakes refused to sell to a particular individual because they identified as gay or lesbian? Of course it would. But that's not what this is. The gentlemen that came to Jack Phillips weren't barred from coming into his shop, and they weren't prohibited from buying anything on his shelf. What he did not do, Jack Phillips, what he could not do is create for them, put his heart that he does into every custom cake design into something in which he does not believe. Jack Phillips serves everybody that walks through his doors. He always has, no matter where they are, what their background is, or how they identify. And for Jack, it's never about the person, it's always about the event. And I'll conclude my opening remarks on this point. Jack Phillips has a history since opening his cake shop of refusing all kinds of custom cakes. And the history and the facts in this case well document this. He has refused historically to create anti-American cakes, cakes that celebrate Halloween because his religious beliefs, his particular religious beliefs do not believe in Halloween. He will not create custom cakes, and he's been asked to do all of these. So these are all specific things that he has been asked to do that he has respectfully declined. He's refused to do adult-themed cakes. Apparently that's a pretty popular request for bachelor and bachelorette items, and cakes celebrating divorce, which I'd never heard of that in my life, but apparently some people are so happy to get divorced they throw a party and want a custom cake. He's declined those requests as well. This man, because those things violate his conscience and he can't put his heart and his artistry into doing something that he doesn't believe in. And with that, I will conclude my opening remarks and turn it over to Mitchell.
You have 15 seconds left, Bill?
I have 15 seconds? Wow.
Perfectly fine.
Thank you very much, and it was very nice to meet you, Mr. Nimocks. And it might be interesting, students, to see, as lawyers take different sides of things, that we do that in a professional and courteous way with each other. We may vehemently disagree with things, but that's what this is about, is that we just talk about them and analyze them, and then we see where it goes, and then we appeal the decision. So no. I have been dealing with these type of issues since 1998. In 1998, two men were arrested in their home for having private consensual sex. At the time, there was a criminal statute in Texas that made it a crime, and they were arrested and taken to jail. There were many states who had these type of sodomy statutes. And after they got out of jail, they spent the night in jail, they came to my office and asked me to represent them. Their names are John Lawrence and Tyrone Gardner. And I spent the next 5 years working with some national LGBT organizations and went all the way to the Supreme Court. And Justice Kennedy in 2003 issued a decision that said, number one, the Supreme Court was wrong 15 years earlier when it said gay people were not protected by the Constitution in a terrible case called Bowers v. Hardwick. And then he went on to say, in golden language, that gay and lesbian people have a right to dignity, have a right to self-determination in their lives, and that the government doesn't have any role in telling them what they can and can't do, especially in private. At that time, there were many, many people, I think President Bush was in office at the time, and people said, if we were to win, families would be destroyed, that the sky would fall and our society would crumble. And of course that hasn't happened. And in fact, 15 years later, it was the Lawrence decision when the Supreme Court talked about the right to gay marriage. As Justice Scalia predicted would happen, he was right. That in Obergefell, the Supreme Court said that gay and lesbian people have a right to marry and have the same rights as everybody else who gets married. Throughout all of those years, especially before, we heard many people express their religious objection to homosexuality, to gay marriage, etc. And I want you to know that I am a true believer of the First Amendment. And I really actually enjoyed hearing counsel's comments about what free speech is about, because I believe it 100%. I welcome contrary remarks. I am not offended when I march in the Gay Pride Parade to see people who think I'm an abomination holding signs. My partner and I have 2 children that we've raised who are 15, and we explain to them that this is America, and they have a right to say whatever they want, as long as they don't hurt us, as long as they don't take our rights away. They have a right to do that. I was an abortion guy, I would walk women into an abortion clinic, and there were protesters outside, and the other people who were volunteering there were upset at what they were doing. I never was upset. I felt that was great that they could express themselves safely, freely, and share their religious beliefs and thoughts. That's what this country is all about. But often, people, particularly religious people, sometimes try to use their religion to impose their religious beliefs on other people and deny them the benefits of government and government protection. It's happened for a long time. And I certainly respect everyone's religious beliefs for themselves, but I don't think that it's appropriate for them to put their religious beliefs and affect my life. This goes back to the 60s, in the first landmark case of Loving versus Virginia. I want to read to you when the couple was ordered to go to jail if they didn't get out of Virginia. The district court judge, who was upholding a law that made it a crime for interracial marriage, he says, "Almighty God created the races, white, black, and yellow, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix." Religion was used in the 60s to try to support the laws that kept people of different races from marrying. As the years passed and we were fighting for the right for same-sex marriage, the same arguments were made. That based upon religious beliefs, we should not allow this to occur. Thank goodness the Supreme Court saw it differently and said religious marriage is over here, civil marriage and the rights that go with it are over here. I am a believer of free speech. I am a believer of freedom of religion. But What this case is about, and what the Supreme Court is going to decide, is whether or not specific goods and services can be withheld from someone because the seller disagrees with the lifestyle, with the person who's there. This was tried before based upon race. In fact, the Supreme Court issued a decision that said a restaurant, and I have the site here, a restaurant said, we are going to refuse to serve interracial people because it, not interracial, African American people, black people, because it offends my religious beliefs. So we, based on our religion, we are not going to serve you. And the Supreme Court said no. You have to serve them. This case that we're talking about here, when I first heard about it, I said, why don't they just go somewhere else? I mean, what's the big deal? Why don't, if they don't, whether it's a pizza place or a cake place, take your good money and go give it to someone who appreciates it. But I didn't really appreciate, because I've never been denied a service. I don't know if you have. If you walked into a restaurant or a store and said, we don't serve people like you. We don't want you here. You can go over there and get things. And what's that like? This case is not about cake. This case is not about cakes. I hope you enjoyed your cupcakes, but this case is not about cakes. This case is about discrimination in the distribution of publicly available goods and services. And what that discrimination does is it causes unique events that the government has a compelling interest to prevent. It's important for you to understand, Texas does not have such a law. This is a Colorado law that specifically says places of public accommodation, which means they're open to the public, can't discriminate based upon sex, religion, national origin, sexual orientation, etc. Texas does not have a law. This is not a federal law. 20 states have such anti-discrimination laws. And the reason for that is that such discrimination deprives persons of their individual dignity, denies society the benefits of wide participation in political, economic, and cultural life. Anti-discrimination laws ensure equal access to the transactions and endeavors that constitutes ordinary civic life in a free society and are precisely tailored to achieve the goal of equal opportunity. In this case, I beg to differ with opposing counsel who gave you some facts that are different than the facts that I understand. The facts that I understand is they really didn't get into discussing the type of wedding cake. I will agree that you could buy brownies or bread or other things, but this baker was not going to make any wedding cake for these individuals. The law does permit people who are asked to do things that are offensive or repulsive to them. That is not a violation of the Colorado law. What's a violation is the blanket policy of, I am not going to sell you a wedding cake because it's for a same-sex wedding. They didn't even get into the details of the wedding cake. What this baker then did is he went to some other bakeries and asked them to bake cakes that for gay pride celebration that were offensive to gay pride rights. And those bakers refused to make such a cake for him. There were 3 of them. He then filed a complaint with the Colorado Civil Rights Commission, and this Colorado Civil Rights Commission denied taking his complaints because they said that the design was offensive to the person, and that was not a wholesale refusal to sell them any cakes. It was that you were being asked to make something specifically that was repulsive or offensive. There's so much, and the time goes by so quickly. There are 2 cases I want to talk about that I think the Supreme Court will be looking at. I want to give them to you as examples. The first is a case brought by law schools against some military recruiters. And the law schools had non-discrimination policies, and the military recruiters at the time had a don't ask, don't tell policy, which prevented gay people from openly serving in the military. The law schools found that offensive and said, under the Solomon Act, that we want to bar the military recruiters from being on campus. Everybody understand? And the law school said because that is forcing us to allow an expression that we find offensive. Okay? The Supreme Court said no. You have to let the military recruiters on because you're talking about conduct, not speech. Having those military recruiters on campus is not forcing you to say anything. In fact, you can have a sign up that says, we don't discriminate, we think that the don't ask, don't tell policy is wrong, blah, blah, blah. Okay? And so the Supreme Court said you have to let them on because we're talking about conduct, not speech, not expression. That same argument is applied here by saying you can be opposed to gay marriage all you want. No one is forcing you to like gay marriage or adopt it. You can have a sign up in your bakery that says, I oppose gay marriage on religious grounds, I find it an abomination, but I am forced to make wedding cakes for everyone under the Colorado civil rights thing, so that nobody is mistaken about his position, his expression. That is allowed, and he can do that. Contrast that with the Boston Irish parade case of the Supreme Court, where a gay group wanted to march in a private parade and express themselves positively when the Boston Irish people who sponsored the parade did not share that expression. Am I out?
About 2 minutes.
2 minutes. The Supreme Court said, no, that's not conduct. That's expression. And we are not going to force the parade to let the Irish group come into the parade because that changes the message that they want. So that's expression versus conduct. And so I think, and I do think, I want to share this, that there may be a line here that the Supreme Court will have to look at when it comes to art and design, etc. I don't think this is the case for it, but the Supreme Court might take an opportunity to discuss that line. But I don't think, as good as these cakes are, that under the facts in this case, that the refusal to sell any wedding cakes because it was the idea of a wedding cake was offensive to the baker is going to pass constitutional muster. The last thing, probably 1 minute, and that is, when someone of a religious belief decides to enter into the public domain of commercial whatever, they have to perform according to the laws that apply in that industry. There are many religions in this world that do not think women should be allowed to work, or that if women work, they should not be paid the same as men. But if they're going to operate a business here in America, they have to comply with the laws that say you can't discriminate against women. Even if it's a deeply held religious belief that women should not be working, you have to let them work and you have to treat them equally. Same thing dealing with race, and same thing dealing with sexual orientation. If you're going to work in the industry, you have to comply with the laws and keep your religious beliefs to yourself personally and privately. Thank you.
5 minutes for rebuttal. Or excuse me, 10 minutes, I believe is the plan. Yeah.
The minutes go by quickly.
They do. 10 minutes.
They certainly do. Thank you, Mitchell. One of the things that Mitchell mentioned, and I want to start with, is the question of dignity. And I think it's important in as much as the men who walked into Jack Phillips' shop are arguing to protect their dignity, that there is a dignity on the other side of the equation, and that's Jack Phillips' dignity. It is not unique to any one group or set of persons or individuals. Dignity is something that belongs to all people. And if we're truly going to live in a tolerant society, And we have to understand and recognize and be willing to embrace the notion that tolerance is a two-way street. Jack Phillips and other artists or artistic expressors have dignity as well. And it is because of their dignity that the First Amendment to the Constitution protects the freedom of religious expression, not belief, expression. Because of their dignity that the Constitution protects free speech and does not allow the government to compel speech. And that's what's at issue here. The government cannot make somebody do something that violates their conscience and their right to speak in the way that they choose to speak. The government can't do it. And that's what's unfortunate about some of the theme I hear in this argument and what my esteemed opponent just mentioned about Jack Phillips being forced to do the wedding cake. This is exactly where the First Amendment draws the line. It protects the government from forcing somebody to speak. And we're talking about when speech is at issue, not everything. When speech is at issue, force somebody to do something against their will. So take, since Mr. Katine brought up the history of race relations in this country, take the classic lunch counter example, where somebody will not allow a black American to sit at a counter and serve them. The Supreme Court has never declared serving somebody lunch like that to be an expressive activity that's protected by the First Amendment. No diner has that. We're talking about a custom commission cake or a painting or however far this will go, because if Jack Phillips doesn't have the right to preserve his First Amendment rights, then all expressive art is on the table. All expressive art is on the table. And not just the professions that I mentioned that are in the commercial realm. We're talking about all kinds of expressive art in this regard. It's difficult, and I don't accept the idea to compare Jack Phillips' religious beliefs to the same religious beliefs that were the cause of our racial history in this country. The Supreme Court hasn't bought into that because the Supreme Court said, as I stated earlier, that people who hold the belief that marriage is one man and one woman have decent and honorable principles underlying those beliefs. Marriage between one man and one woman is still a mainstream religious belief, accepted by most Protestant religions, by the Catholic faith, by most denominations of Judaism and Islam. So the idea that this is somehow a left field, doesn't really exist religious belief is a little bit difficult to grasp. But this is exactly what the Colorado Human Rights Commission called Jack Phillips. They characterized his beliefs to that of, quote, a perpetrator of the Holocaust, unquote, and slave owners, which, of course, to Jack Phillips was offensive since his father fought in World War II and actually liberated a Nazi concentration camp. Of course, he doesn't view himself in that regard, nor does the Supreme Court, nor most of the religions. Jack Phillips sat down at his table with these two gentlemen, which is where he sits down to go over custom design. And once he understood what they were doing and that he could not help them create, the gentleman wanted a rainbow cake with certain thematic elements to it, and would not do that. And this is not just about Jack Phillips. There's another case before the Supreme Court that we haven't mentioned yet, called Arlene's Flowers, about a floral artist in the state of Washington who served a particular couple for 9 years. They were friends. When they came into the shop to buy flowers for each other's birthdays and things along those lines, she would hug them. They were on a first-name basis. But when this couple decided that they wanted her to do floral designs and special designs for the things that they wanted for their same-sex ceremony, she politely told them, I have to draw the line there because that's where my faith and conscience kick in. I can't do that. Why do I mention that? Because you don't maintain a 9-year relationship with a same-sex couple if you are actually perpetrating the Holocaust, or like those who perpetrated some of the racial discrimination that scars the history of this country. It's just not a fair analogy. And the Supreme Court acknowledging that in the Obergefell decision, I think, is important. How am I doing on time, Doctor?
You have 4 minutes.
4 minutes, okay. So Mr. Katine mentioned the Rumsfeld case, and I want to briefly address that. That case is, quite frankly, not going to decide what's before the Supreme Court right now. That was a unique case about the right of the U.S. government to raise armies, which is a specifically enumerated right under the Constitution. And when you have a university that accepts federal money, they have to comply with the Solomon Act, which means recruiters get to get on campus and recruit military members, even if people on campus don't agree with the military's don't ask, don't tell policy. That's one of the provisions of doing that. And there's a little irony in the Rumsfeld case, in my opinion, because if a university is supposed to be a marketplace of ideas, where we get exposed to all ideas from all spectrums so we can become more informed and educated individuals, that certain ideas were being prohibited from this college campus. But the Hurley case that Mr. Katine mentioned is more of an appropriate case, because here you had a St. Patrick's Day parade going through the streets of downtown Boston, which Massachusetts law declared that this parade was a public accommodation. It was the same thing as a business open for service. And the parade is an expressive activity. It communicates a message. It communicates a particular message, and the parade organizer specifically said to the gay and lesbian organization that wanted to put an entry in the parade, we don't agree with your viewpoint, and your viewpoint is not consistent with the message that we want to transmit through our St. Patrick's Day parade going through the middle of downtown Boston. And the Supreme Court said, absolutely, you have the right to communicate the message that you want to communicate. Whether right or wrong or good and bad, the Supreme Court didn't say anything bad about the gay and lesbian organization or anything good about the St. Patrick's Day parade organizers. There's a principle in play here. If you are expressing yourself, the First Amendment kicks in, plain and simple, and allows you to express yourself in the way that you want to express yourself, free from governmental interference. That is fundamentally what's happening here. And Mr. Katine mentioned that once you open your doors to the public, somehow, and I'm going to mince his words here a little bit, but not intentionally, the rules change. Now you're engaged in commercial activity and the First Amendment no longer applies. That's not entirely the case. We do have a commercial speech doctrine in the United States. However, commercial speech doctrine has never, ever been applied to the artistic professions. It has never been applied to an artist. It has never been applied to a speechwriter, a cake artist, anybody along those lines. And they open their doors, they are free for business, and they do it, that's their profession. They do it for profit, okay? That doctrine has never been applied to the expressive arts. And that's what we're talking about. We're talking about expressive businesses like cake artists here. The idea that the law would require an expressive artist to paint something that they don't want to paint, or a speechwriter to write something that they don't want to write, violates the First Amendment, plain and simple. That cannot be what the law requires, and nor would it be consistent with American values of free speech.
I'd like to add 3 points to my prior comments. The first is that historically, when minority groups make advances in the law, there's often a backlash. It happened racially, and after Lawrence versus Texas and the Obergefell decision came out, I actually thought to myself, and my law partner John Nechman is here, and we all kind of said, well, is that it? Are we done? Is there nothing else to do because we just won the Supreme Court? And it didn't take long for us to realize that people who disagreed with the decision, who found it offensive and overreaching, were going to do everything they could to pull it back, to restrict it. And that's what I think this is about here. And I know we have a very close court. I'm very thankful that Justice Kennedy is still with us on the Supreme Court because he wrote all of the gay rights decisions, and he may write this decision. I don't know. We're going to see. I hope he will. I hope he'll stay a little longer, like 3 more years. Anyways, but this is serious. This is serious because I don't think it will end here. I think that based on this decision, if the Supreme Court were to say, okay, we go with you, Mr. Baker, you don't have to sell wedding cakes as opposed to make them. You don't have to sell any wedding cakes or to gay people. If the baker is permitted to discriminate due to artistic or expressive content, then what's to stop other businesses from doing the same thing? Hair salons, many hairdressers feel they're artistic. Tailors who make clothing. Restaurants who cook food, specialty food. Architecture firms, florists, jewelers, theaters, and dance schools. You know, at the Supreme Court, there are some special rules. And something that we haven't mentioned yet that I think I just want to mention is that even if cake design were found to be expressive in itself, okay? Even if it was expressive, and I'm going to say to some degree I can see that. The government may regulate expressive conduct if it furthers an important or substantial governmental interest if, this is the test. Number one, the government interest is unrelated to the suppression of free expression. And number two, if the incidental restriction on alleged First Amendment freedom is no greater than is essential to the furtherance of that interest. Those are kind of technical, legal things that I have to repeat and use up all my time. What I want you to know is, I don't think the Supreme Court has to say, you're not an artist. This is an expression. The Supreme Court can say, we recognize that you are an artist. You have some expressive qualities to what you do. But we believe, Supreme Court statement, we believe the state of Colorado adopting this anti-discrimination law is, first of all, it's neutral to free speech. It simply says you have to make your goods and services available to everyone equally. The government interest is unrelated to the suppression of free expression. And number two is, the incidental restriction on the First Amendment freedom is not any greater than is essential to further the interest. Acts of discrimination in the distribution of publicly available goods and services cause unique evils that government has a compelling interest to prevent. So, even though they may or may not find it to be expressive, I don't think that decides the issue. I think that state, city, and national anti-discrimination policies are of a very important governmental nature and service that can even be applied even if it was found to be artistic. Thank you.
Would you each like 5 more minutes, or would you like to open it up to questions and answers?
Q&A is fine with me. It's a little tired.
I'm perfectly fine. Good to receive questions.
You guys have all been patient. Do you have questions? I saw you first.
Okay, I have a question for Mr. Nimocks. So you previously cited a case, Falwell versus Hustler magazine, and in this case, Falwell is a famous minister, so a public figure. So even though he argued that it was private facts under false light, the court still ruled that it was under the protection of First Amendment. So how do you think this case is relevant to the case in front of us today? Do you see these two as factual difference without legal distinction, or how would you justify that we can apply the same First Amendment protection from the magazine case to our case?
Yeah, I cited that case, the Falwell against Hustler magazine case, as an example of the type of speech that I think mainstream America would deem to be vile or have little redeeming value, but yet nonetheless receives protection of the First Amendment. I don't know that that case will play a large role in the court's decision, because the mechanisms of that case, that was an infliction, if I recall correctly, an infliction of emotional distress lawsuit that Reverend Falwell brought against the magazine. So the mechanism, the procedural mechanisms and how it came up to the court is obviously different. But that case in the Westboro Baptist Church case I mentioned, Phelps against Snyder, are just talking about just to demonstrate from a demonstrative standpoint the fact that the doctrine of free speech doesn't know boundaries in terms of taste, so to speak. And I think that's important. And so whether you agree or disagree with the message or the religious beliefs of Jack Phillips, is irrelevant under the First Amendment, is the point I'm making.
Thank you.
We'll keep you two together and then I'll go back.
Mr. Nimocks, regardless of whether or not it would violate the Civil Rights Act of 1964, do you believe that someone in a creative profession like a chef should be legally able to deny service to someone who is black simply because they're black? It seems like that is the sort of argument that you're trying to make here, that their religious, deeply held beliefs would override any other consideration, I guess, in the law.
Well, the first consideration we have to remember is that the Constitution is the preeminent law of the land. And so to the extent that the Constitution conflicts with anything else, the Constitution prevails, okay? And when we're talking about free speech, and here artistic expression, which is a modality of free speech, the First Amendment has been very consistent throughout the years that you have the right to speak freely, even if it's vile, even if it's offensive, or everybody disagrees with it. And this is, I think this is an important thing because you said something in your question that I completely disagree with, and I think is a talking point that keeps getting batting it forward like a tennis match in this case, and the idea of denying service. Okay, he didn't deny service, and this is important constitutionally. He said, no, I'm not going to lend my artistic abilities to doing something I don't believe in. And that is a whole different question constitutionally from just serving somebody. If Walmart said, we are denying service to all black folks, that's a denial of service, which is because Walmart's not doing anything artistic by putting stuff on the shelf and people coming in and buying and go through the checkout counter. But when somebody is doing something artistic, it's a whole different ballgame. The First Amendment and the Supreme Court has always said it's a different ballgame.
Oh, sorry. Following up really
Okay.
quickly. Is there any evidence that the folks in this case specifically asked the shop owner, Mr. Phillips, for any specific design? Because from what I understand, they asked him that they said they wanted a cake for their wedding, and regardless of any, they didn't get into any details. They didn't say they wanted a rainbow on it. They just said, we want a cake for our wedding. We're getting married. And Mr. Phillips said, I do not believe in same-sex marriage, therefore I refuse to do this for you.
Right.
So is
every wedding cake he does is custom.
sure, but
So this is yeah, but the point you're making is irrelevant because the fact that he let them know in advance before they got to the details doesn't change the case. I guess the implicit suggestion of your question is that, oh, they needed to get to the details and then it would have been permissible for him to say, I can't help you, as opposed to telling them before they got to the details. It doesn't matter. Every wedding cake he does is custom design, and so that's the whole thing. He doesn't do wedding cakes and stick them on the shelf. No, he does. I don't know a baker that does that.
sure. But would someone like an impartial third party be able to tell whether something's a gay cake or not? Is that like is?
Oh yeah, absolutely.
Really?
And if you read the amicus briefs by some of the cake designers, one of the points they make is that some of the most expressive wedding cakes they've ever seen have been the cakes done for same-sex weddings.
But is that the case here? Is there proof that?
Well, it doesn't matter. The case wouldn't turn on that.
Sure. So even if it was a plain cake, you would still agree with him denying them this?
A plain cake wouldn't be a custom cake.
It would. What if it had no significant gay markings? I guess.
He told him he would sell him anything that he has in his store. Okay.
But not a wedding.
But not a wedding cake.
So, which would be custom. And by the way, they had custom ideas in mind. They've spoken publicly about that. One of the guy's mothers talked about all the different things they wanted to do with the cake. So I mean, there's no debate about the fact that they wanted a custom wedding. The other side's not even debating that that they wanted a custom wedding cake. So I mean, that's not an issue, and the case won't turn on that.
But I do think that what the Colorado amendment of the Colorado statute talks about is refusing to sell similar goods and services. And I understand that this baker makes custom cakes. Having had a case at the Supreme Court, I understand, and actually just as lawyers, judges and juries don't always get all the facts. They don't always get all the facts right. They kind of hear what people are saying and then try to focus on things that support the decision that they're going to go with. So I actually think it would have been different had they gotten into the artistic nature of the design and then had a disagreement about it. And they said, you know, they wanted, I don't know, 2 men on top of the cake. And he said, I'm not comfortable doing that. I'll make you a plain custom cake with no gay symbols or whatever it is you said. That, to me, and I understand that he's not in favor of gay marriage and he doesn't want to support that. Like, cakes are important at weddings. I understand all that. And that's what this case is about. Not a cake about. But I think, and I may be wrong because I've only read the things that are available, is that his policy is, I don't make wedding cakes for same-sex marriage because I don't believe in it, and I don't know if he went as far as says, I don't want people to interpret that as that I'm supportive of this, because I'm not, and my religious beliefs are not that way. So you never know where the Supreme Court's going to focus or what they're going to do or they're questioning. In the Lawrence oral arguments, Justice Rehnquist said to the district attorney who was arguing, he says, if we do away with the sodomy statute, will that let gay people be kindergarten teachers? That's what he asked. And the whole audience like gasped, like, well, of course they're already kindergarten teachers, but he asked that. And these are, the judges are just people. They're into those minutiae and details. So although it might not be the focus of this, you never know where they're going to go and what they're going to ask and what they're going to do. That's why you all know you all are welcome to observe oral arguments, right? If you want to go and spend the night in line, there's a public section for oral arguments at the Supreme Court. I'm going to be in the lawyer line. I'm thinking of going, but when we did Lawrence, there were law students and college students lined up who slept overnight to hear the oral arguments. Just wanted to make sure you know that the Supreme Court is open to everybody if there's a case of particular interest to you.
Hi, I have a question for both of our guests this evening, and it's about the precedent this case would set. So my question is really, what kind of precedent or precedents does this case set for free speech in regards to other services that might be more consequential than, say, buying a cake? Services, like for example, does the ADF's argument extend to doctors having the right to deny medical care to patients whose sexualities might violate the doctor's own sincerely held religious beliefs? And I understand the difference that you've discussed between a service specific, the difference between selling just a brownie or a specialized dessert. So one case that came to mind was that in Michigan in 2015, a pediatrician refused to see a lesbian couple's baby because her own sincerely held religious beliefs that marriage should be between men and women exclusively, and that only married couples should have children. That was basically her reasoning behind not seeing this child. So my question is really, to what extent does this argument go?
You want to take a stab at that?
Well, I'm curious what happened to that pediatrician, because that to me, and I'll share with you that you know, dealing with the abortion issue, I think that's such a hot topic and such a religious sensitive topic. I think there's something different about a doctor being forced to perform a procedure that is offensive to their religious beliefs, and quite frankly, I would guess that they would not be compelled to do something like that. The circumstance you described is not a specific procedure, but is more along the lines of what I see here, and that is, I'm not going to provide any services to you because I don't like who you are. I don't believe in 2 women or 2 men raising children. I think there's a difference between not providing any goods or services because of the person versus a specific, and I actually think there's some similarity here between a specific design on a cake or a specific medical procedure that is offensive. So what's interesting about the Supreme Court, and then I'll be quiet and let Austin talk, and that is, it is amazing to me that the Supreme Court's decision covers millions and millions of people. I know that that's a little obvious, but when these 9 judges, when 5 of the judges make a ruling, and it affects our entire country, it blows me away. And also, because we're used to having an appellate option, they're the last word, at least until they change it. It's just astonishing to me, and I didn't realize it until I was involved in it, that the impact in that little room has on millions and millions of people and lives. It's really significant, and you just got to kind of let that sink in to really realize that these decisions that they make, and this one could have that. So you asked about precedent. This is the court that has the most powerful precedent in our country. So it matters what they do.
I'm hopeful that the precedent that comes out of this will be a reaffirmation of a long tradition of upholding free speech in all kinds across the spectrum. And in this context, obviously the speech is artistic expression, and if the Supreme Court rules in favor of Jack Phillips, I'm hopeful that the precedent will affirm the right of artistic professions to maintain their conscience, whatever that is, in terms of what they choose to accept a commission to do and what they choose not to do across the board as far as that's concerned. And so, and the facts of this case really set up well for that, in my opinion, because of Jack Phillips' particular history of exercising his right to say no, whether it's a Halloween cake or the adult theme parties or whatever. So you have a cake shop owner or a cake artist who has a history of saying, no, that violates my conscience, I don't want to do that. And then now you have this circumstance in the wake of the Obergefell decision. And so my hope is that the Supreme Court will continue to uphold the First Amendment, which it has traditionally done, even in the face of social contention, difficult circumstances, difficult facts, whatever the case may be. So,
I actually want to say one more thing that kind of supports what Austin says, actually, because I'm here thinking about this. And I think we can agree that the baker didn't say, I'm not going to serve gay people. Okay? And thinking about Halloween and the other holidays, I could see, you know, the real question is, to what extent does a gay marriage make a gay person? You know what I mean? Where it says, look, you're celebrating Halloween, I'm not going to make you a Halloween cake, but I'll make you some other cake, but just not a Halloween cake. So the Supreme Court could look at dicing this up a little bit it's going to be interesting. I just want to share that with you, that here I'm saying, well, they're not serving gay people, you know, or as opposed to not serving black people in all respects. This is a particular event, particularly important event, but I think the record shows he would make, it's not that he's not serving them at all. So it's interesting. It's interesting.
In the entrance of balance, we're going to move over to this side of the room, the gentleman in the lavender shirt. That's lavender, isn't it?
So my question is, I think it was mentioned that the baker is claiming rights under both the free speech clause and the free exercise clause, and both of you, I think, mostly addressed the free speech clause. So my question is, suppose like the Constitution didn't have freedom of speech, it only had freedom of religion. How would each of you analyze the case if that was the only right that the baker could claim?
Yeah, and so that is part of the case. That's a very good question. And the freedom of religion is historically been interpreted by the Supreme Court to include the ability to exercise one's religion. That's why it's called the Free Exercise Clause. And so, you know, one of the arguments that we hear against Jack Phillips is that, well, he can believe whatever he wants to believe, but when it comes to actual actions, he can't do what he wants to do consistent with his religious beliefs. And that's just not what the Constitution protects. It's like telling a Jew that you can be Jewish and you can believe in all the Jewish tenets, but when it comes time to wear your yarmulke, that's off limits. You can't express yourself. Or telling a Muslim that they can't wear a head covering. It doesn't go that far. And even though some of those expressions in religion may offend other people, the freedom of religion is specifically protected constitutionally. You don't have the right, for example, to be free from being offended by somebody else's religion. And you don't have a constitutional right to have a cake made by the baker of your choice or a picture taken by the photographer of your choice. And so those are kind of the values, you know, as I kind of see it, you know, being pitted against each other. And so I think on a freedom of a religion claim, you know, I would hope that he would prevail as well, especially when you look at the facts. So the facts of his case is that when he opened it, he dedicated his shop to God. He's a very deeply religious guy. There's nobody that disputes that. That everything he does in his shop, he does to honor his Lord and Savior Jesus Christ. And this is documented not just from the case itself, but it existed previous to the case. And so he's clearly, unlike a lot of bakers, going to work every day in a religious expression. And we see that with a lot of individuals in for-profit or non-profit circumstances, whatever the case may be. So, I mean, the Supreme Court has confirmed, like in the Hobby Lobby case, yes, they're a for-profit corporation, but they're owned by religious individuals, and this is a ministry that they operate, and they have that protection as a ministry. So I would hope that if the Supreme Court reaches the freedom of religion question, which they don't have to, that they would also affirm his freedom of expression, or excuse me, free exercise of religion.
Thanks.
And my response is that a neutral law of general applicability does not violate the free exercise clause. And so there are many religions that I talked about earlier that have prohibitions that violate our civil laws, dealing with women and race and gay people. So I actually think the free speech argument is a stronger one than the religious argument, the free exercise argument, because of the Colorado anti-discrimination statute. But it could come up, but I actually think the free speech one is a little stronger.
And it's ironic to that end, talking about the Colorado statute, or at least it is to me, is that the same Colorado statute under which he is being prosecuted simultaneously protects religious.
It does.
You know, and so it's a, you know, it's a question of competing values. There's no question that there are deep held beliefs, maybe not all religious, but beliefs on both sides, and there are genuine motives kind of clashing. The question is whether these two things can coexist, or whether the freedom of speech, as Jack espouses, and his freedom of religion will succumb to that the other value being espoused is more weighty than his. I certainly don't think it is, and I think there's room to coexist, especially when you look at the purpose of the non-discrimination laws. And somebody mentioned this earlier. You know, historically arose in the context of people not being able to get essential services like hotel. You think about the Heart of Atlanta hotel case, which is a very important case the Supreme Court decided, where you have a black family traveling and couldn't get a hotel room. Okay? The government's interest is dramatically different in services that would be viewed more essential, like a hotel room or getting gas, and then something that is not necessarily necessary to everyday life, like a wedding cake. You know, so it's like And so when you're doing freedom of religion claims, there's often sometimes a balancing on whether the government has a sufficient interest to compel that type of thing. And so, you know, he's not selling. This is not a grocery store or a hotel or a gas station. This is a bakery, and it's not what I would characterize as an essential service. And so when you look at the purpose of the law, is it really designed to catch everything in that regard at all costs? Or is there room in our legal scheme, in our tolerant society, for expressive professions, you know, like Jack, to have some free speech and some free exercise of religion values in doing their daily things?
And see, that's going to be left up to the Supreme Court, whether they're going to make that distinction or not. I want to say I've spoken at a number of universities, and the quality of your questions here at Rice is way above any other college students I've found. It's like, they know that. They know that?
They know that.
Well, I want my kids to go here now, so good job.
I was just going to say, the Heart of Atlanta case, as I recall, was decided on the basis of the Interstate Commerce Clause, but the motel was engaged in interstate commerce, even though they could claim they weren't. Anybody traveling through the state of Georgia could be engaged in interstate travel, therefore they're engaged in interstate commerce, therefore Congress had a right, or the authority, to regulate that. I think you could stretch making cakes to that extent too. You're making cakes, it's got ingredients, they come to the state from various parts of the United States. It's interstate commerce. So you could,
Except Congress isn't regulating. Congress, excuse me, isn't
it's
regulating.
a state law.
It's a state law, and so
Right.
that the Interstate Commerce Authority is not necessarily exercised by the states, and so it might be a different question if it was a congressional law.
Yeah.
That was the law under which Masterpiece Bakery was being prosecuted. So.
One more from this side, and then we'll go back over to that.
Dr. Brace, we got a...
Oh,
Yeah,
are we out of time?
Okay.
I'm sorry, I would have given you more questions. They were great questions, and you guys were great. Thank you very much. I didn't mean to conclude with my question.